Thank you so much, everyone, for being here. We're really excited to talk to you about this kind of really interesting and timely issue about employee speech and politics and the intersection between the two in the workplace. I'm Ben Buchwalter. I'm an attorney in Farella's mighty employment team.
And I'm Jackie Gerson, and I'm also an attorney in Frella's employment team.
So let's jump in. If my slide will progress, there it is. So here's the agenda for today. We're going to start out by talking about some of the existing employment and discrimination, harassment, and workplace political speech laws. We think it's really useful to use that as a guidepost for what we're talking about today, because although we'll be talking about some key current events. It's important to remember that no matter what's going on in the news, the employment discrimination laws on the California level and the federal level that we know and love continue to apply. We're also going to address some of the recent administrative guidance and executive orders from the executive branch addressing politics in the workplace and employee speech. And then we're going to dive into some interesting current events topics. And the reason we're doing this is because we think that as we're talking about employee speech in the workplace, it's a nice framing to focus on some of the hot button issues that we see in the news every day, and use that as a guidepost to address how employers are responding and some of the risks employers are seeing, and also how employers are navigating those risks and trying to mitigate unforeseen challenges. And then finally, we're going to talk about DEI policies and politics related to DEI policies. As we know, many employers have been wondering what to do with their existing DEI policies, and employees who are outspoken about their views about what employers should be doing. Should they be embracing DEI more? Should they be backing away from it based on what the current executive branch has said? So we'll dive into what we've seen there and some best practice advice. Here are some headlines we've seen recently about lawsuits relating to political speech in the workplace and the news. A couple things I want to note about this. One is that, we see these headlines in the newspaper, and we don't actually know what happened in the underlying lawsuits. Yet sometimes when you see that headline, sometimes connected to a particular company, it can leave an indelible mark about your impression of what that company is like, even though you don't actually know what happened there. The reason I emphasize that is because we'll be talking about employer tactics to help mitigate risks, but sometimes one of the risks that we're thinking about isn't necessarily legal in nature. It's also about the public impression of the company that may result if some of these lawsuits are in the news, and someone might get the impression that the company did something illegal when in fact the explanation is completely understandable. The other thing to note here is that if you dig down to what these lawsuits were actually about, most of them don't actually necessarily hinge on what's going on at the federal level. At the end of the day, when you see a complaint, the causes of actions that are pleaded are often state-based. California employment law addressing discrimination, harassment, and retaliation, and California Labor Code statutes addressing political speech. And I mention that because it can be so tempting to get wrapped up in what's happening at the federal level. What is the president doing, and what is he saying? But at the end of the day, what's going on locally and on the state level is often more central to an employer's considerations of what types of risks they should be expecting based on political conduct or speech that happens in the workplace. So the way that I like to think of this is, it comes back to a common organizing phrase that many of you have probably heard, which is think globally, act locally. In our case, probably better to say think nationally, be aware of what's happening on the national level, but act locally. Really focus on, what are the existing state and local employment laws that we need to be aware of, and how can we be mitigating risks most effectively? How do we address employee speech in the workplace, even on really tricky, sensitive topics, in a way that helps support the workforce and also mitigate risks. So with that, I'm going to pass it to Jackie to talk about some of the workplace political speech standards and existing laws that will frame our discussion today.
Thanks, Ben. And so, as the slide shows, California and at least 11 other states have laws that prohibit employers from limiting an employees' political speech. The California Labor Code also states that employers can't discharge or terminate employees for lawful conduct occurring during non-working hours and away from the employer's premises. So, for example, if a California employee attended a Trump rally and the employer found out and then terminated them because they went to that rally, that would violate these code sections because it would be seen as a limit on the employee's political speech. These California Labor Code sections have some teeth to them because any employer who violates them is guilty of a misdemeanor and will be responsible for the acts of their agents. So that would include, officers, managers, or other employees. New York also has a similar labor code section that prohibits employers from discriminating against an employee based on their political activities, which are specifically done without use of the employer's equipment or property. So this is an interesting distinction because essentially it allows employers to crack down on employees who use company premises for their own political activities. So employees in New York should not hold political campaigns or protests in an employer cafeteria, for example. Other states offer far more limited protection for employee political activities. For example, in Illinois, the law only prohibits employers from keeping a record of an employee's political associations and activities. So employees in Illinois may have to rely on federal protections for their political speech. So, as you all know, but we'll briefly summarize here, um, there's many current anti-discrimination laws that interact with employee political speech. And as we'll cover in some of the next slides about this administration's executive orders, it's important to remember that discrimination and harassment laws still apply and haven't changed. So there is some inherent tension there that we want to recognize between the law and what the Trump administration is pushing for. But I'll just give a brief primer right now. So, all federal, state, and local laws regarding discrimination, harassment, and retaliation make it unlawful to discriminate against an employee based on their race, color, religion, sex, and national origin to ensure equal opportunity in the workplace. Employees can allege various theories of liability based on discrimination. For example, disparate treatment or impact, harassment, or retaliation. So, as Ben was mentioning, it's really important for employers to carefully review the law in their specific jurisdiction when addressing discrimination claims because some laws may offer greater protection for the employee or the employer. For example, California's Fair Employment and Housing Act, which is commonly referred to as FEHA, places a duty on the employer to investigate any harassment claim brought by an employee and take action if substantiated. So that's very notable for employers in California needing to pay attention to employee complaints. And similarly in New York, an employer will be held vicariously liable for discriminatory conduct of an employee or agent if the employer knew of the conduct but failed to take action, or if the employer should have known but failed to prevent the conduct. California law also bars employers from retaliating against an employee for whistleblowing, which is when an employee reports violations of the law or refuses to violate the law in their employment. So, if an employee complains about unlawful discrimination, that's protected activity, and any adverse employment actions taken against that employee after the complaint could constitute retaliation. These standards will come into play as I discuss the Trump's administration's latest executive orders. So, I'm sure as you've all seen in the news, the current administration has issued a flurry of executive orders addressing workplace speech and rhetoric regarding many of the hot topic issues we'll be discussing today. Um, and these on the slide are just a few of the areas being targeted. But as I mentioned, it's important to keep in mind that these orders don't change the law, but they might alter how the law is applied, which we're already seeing in some cases we'll discuss later. So to kind of take a closer look at a few of these that cover some hot topic issues, the first executive order on the slide, which is titled, quote, Ending Illegal Discrimination and Restoring Merit-Based Opportunity. So the purpose of this order is to effectively end DEI efforts, and instructs federal agencies to end DEI in federal contracting and encourages private employers to also do the same. So basically, federal contractors can no longer factor in race, color, sex, sexual preference, religion, or national origin in their employment practices in what the administration says, quote, would violate the civil rights laws. This order has already pushed large federal contractors, such as Boeing and Raytheon, just for example, to dismantle DEI programs that would have, potentially had pushed the companies to have fixed outcome targets. For example, like recruiting a certain number of women or historically underrepresented groups. So while this order doesn't change existing discrimination law, it sends clear messaging that the government is increasing investigation and enforcement activities, so employers should review their current employment practices and DEI initiatives to ensure compliance. We do encourage employers to reiterate their belief in the same principles of non-discrimination and equal employment. The second executive order I'll be discussing is titled Defending Women from Gender Ideology Extremism and Restoring Biological Truth. So the administration has directed federal agencies, in their words, to only recognize two sexes, male and female, and advised all employers, including those in the private sector, to review their related policies. The order's stated purpose is to protect women from men who, quote, self-identify as women and gain access to intimate single-sex spaces and activities designed for women. For federal agencies, this order suggests that using the term sex instead of gender would help promote the order's policy. And for federal employees, this is a pretty large encroachment on their workplace speech generally, and for many, their direct identities. As I'll cover later, the EEOC has responded to this order, with the acting chair promising to remove this, quote, gender ideology and dismissing some of their own even gender identity workplace harassment cases. And this last executive order, which addresses anti-Semitism, builds on a previous order from the first Trump administration. This order, in the wake of the events of October 7th, requires a government-wide effort to combat anti-Semitism. The EEOC has also promised to hold campus workplaces accountable for what they consider to be anti-Semitism under the guise of free speech. So there's no doubt here that the administration, is trying to have a chilling effect on certain speech that it doesn't view as aligning with its priorities. And here that would probably be, pro-Palestine and associated anti-Israel protests that have occurred across the nation, and in employee political speech generally. I'll turn it over now to Ben to discuss some key themes we're seeing across these hot topics and political issues.
Thanks, Jackie. So this is a good time to note, before we dive into some of these hot topics, and after we just address the Trump orders, that we view these issues from the perspective of employment lawyers, and specifically, management side employment lawyers. So we'll be looking specifically at um, how employers can mitigate risks related from employee speech and politics in the workplace. We're going to do our best not to express our own political opinions because that's really not what you're here for. But it is important to note that regardless of what the employer's political opinions are, or what an attorney's political opinions are, the focus is on mitigating risks from employees. So on this slide, we presented some key takeaways that kind of cut across each of the political issues that we'll be diving into in more detail. The first, with a bullet, is really social media. This is probably unsurprising to most of you because, in any employment litigation, social media has become a key aspect of many cases. It used to be that the primary way that you interacted with your colleagues was in the workplace, in the hallways, in the kitchen, wherever it is. And now, since we spent a couple of years working from home, many of us now work from home on a hybrid basis. So much of our interactions with our colleagues happens either, online through email or Teams or Slack, whatever it is. But also, some workplaces, it's a common practice to follow your colleagues on social media. So even though, what someone writes on their personal social media account can feel like a personal act, it can have an unavoidable impact on how people are viewed in the workplace. And if someone's writing about a really charged political issue on their social media, it's sort of unavoidable that their colleagues might notice that, and it might color the way that they view that person. For better or for worse, it's a consideration that employers need to be aware of. So social media and being careful about how political comments are addressed from social media is an important aspect of this. Another part is free speech and a perception of First Amendment protection. One thing we often see from employees when they're disciplined for conduct that violates a company's policies is, well, I was expressing my freedom of speech. It's important to note, of course, that the First Amendment applies to government action. It doesn't actually apply to private employers. So, even though an employee might say that, a private company is actually not violating the First Amendment to the Constitution if it is applying its speech or workplace conduct policies. That said, since we're talking about mitigating risks here, in addition to actual legal liability, it's important to note that even if an employer is 100% right about that, and they're within their rights to take action based on someone's speech, the perception that they're violating someone's First Amendment rights can be enough to lead to a tricky situation or even lawsuits. On that point, a lot of the legal claims that we see about speech aren't actually focusing on the labor code sections that Jackie went into before, labor code sections 1101 and 11.2. They're often hinging on related kind of black letter employment law relating to discrimination or retaliation. An example of that is if someone is making a political comment on their social media about, let's say, about the Israel-Gaza conflict, and they are either Jewish or Muslim, and then they are terminated based on the speech that they made on social media. They could view that both as a violation of their political speech under the California Labor Code sections, but also as discrimination based on their religion or their national origin or some other protected characteristic. They could also view it as retaliation for engaging in a protected activity. For example, if they're saying my company is not doing enough to address this, that could be viewed as a legitimate comment about the terms and conditions of their employment protected by the National Labor Relations Act, and the company's action disciplining them for violations of the standards of conduct or the workplace conduct policies could be viewed as retaliation. Now, another key thing that we're seeing is shifting expectations. We all went through sort of a 180-degree whiplash situation when the second Trump administration came into power, because for the last 4 years, the Biden administration was really focusing on historically disadvantaged or underrepresented groups, and trying to, implementing policies that can sort of help build up people who have historically not been respected in the workplace. The Trump administration, as we all know, has been taking a different approach, and viewing it as, the Biden era basically going too far in that direction. And from the Trump administration's view, based on their executive orders, it seems that there's a view that that other protected characteristics, men, certain races, have been disadvantaged, and they're focusing on trying to change that balance. And then obviously, the Trump administration, he's in his second term. So, at the moment, it seems that the Trump administration will end, although of course we can't be sure. And so there'll also be a consideration of what's next. Will it be in the line of what the Trump administration is doing now, or will we go another 180 degrees back to what the Biden administration was focusing on, or will it be something totally different? It's just important for companies to be aware of these changes and to try to stay nimble to address them. And then again, as we mentioned before, there are state-specific differences that are at play here. There's what's happening on the federal level, but then, each state has their own political ideology. And so certain speech that occurs in California may be treated differently than speech that happens in a more conservative state like Utah or Texas or wherever it is. And so again, it's important to think globally, think nationally, consider what's happening on the federal level, but be laser focused on the employment laws specific to your state. Now, as we dive into some of these topics, we'll be focusing on sort of two prongs. One of them is what's happening related to these political issues, and the second is what is happening when employees are raising speech related to these political issues, either supporting what's happening or challenging what's happening, or what the company is doing about it. So we're going to start out talking about abortion and workplace health issues. Before I worked at Farella, I was in-house counsel at a tech company, and when I worked there, the Dobbs decision came down from the Supreme Court. And many employers, as I'm sure most of you know, spent a lot of time figuring out what's the best way for us to address this, so that we are compliant with existing laws, but also we're supporting our workforce. And one solution that many employers came up with at the time was to provide, to cover the cost of travel out of state to access abortion services if those services were not available in the state they were working in. Now, to make sure that this was a program that was available to all employees, many employers frame this as generally as medical health services not available in their state. So not only specific to abortion, but if there was a medical service not available in your state, many employers would cover the cost of traveling out of state to access that. one key consideration that employers had to keep in mind when doing that was to look at what their insurance policies covered, and also what their vendors covered. Many employers work with a fertility service like Carrot, or there are many others that help provide those services. And I know that those companies at the time really had their hands full figuring out how they were going to adjust what they provided to make sure that they were meeting the employer's needs. Um, and relatedly, over the last couple of years, we've seen a shift in how the EEOC has addressed abortion discrimination claims. A few years back, the Pregnant Workers Fairness Act actually included abortion as a, quote, related medical condition that was covered under the law. And consistent with that, the EEOC from 2022 to 2024 identified pregnancy and abortion discrimination as a key priority. Predictably, that has shifted somewhat. We don't expect that to be a focus of the Trump administration yet. There have been some unexpected actions there. For example, the Trump administration requested that a court dismiss a case challenging the viability of mifepristone, the abortion drug, from being able to be transferred between state lines. So there may be some unexpected moves from the Trump administration there, but I think we can reliably say that the EEOC is not likely to focus on this type of discrimination in the way that it has in the past. Now, shifting to employee speech and the implications surrounding abortion. I mentioned at the time when Dobbs came down and employers needing to address that. One thing employers were similarly grappling with was employee speech related to that issue. Many employers have employees interacting with each other through Teams or through Slack. And if you use Slack, there are work-related channels and there are kind of more not work-related channels. Maybe some things for fun, some things specifically designed to talk about what's happening in the news. And one thing I saw, and I think many people saw, was people sharing some pretty personal information in those Slack channels about their own views about abortion or what the Supreme Court had done, and even their own experiences going through that. So when dealing with those types of disclosures, it's important for employers to be very careful about taking any action based on speech that could be viewed as violating the company's standards of conduct or workplace conduct policies. That's not to say that you can't take action based on speech that is offensive or harassing. Of course, employers can do that if there's a policy violation. But it's just a reminder to be especially careful about that, given some of the laws that we're addressing here, labor code protected political speech, but also a perception that discipline based on these things could violate someone's protected characteristic. And with that, I'm going to pass it back to Jackie to talk about some other key issues that we're seeing in the news right now.
Yeah, thanks, Ben. So kind of following up on that topic, and kind of rights that have shifted under this current administration. Recently, the EEOC has actually moved to dismiss 6 of its own lawsuits filed on behalf of workers alleging gender identity discrimination. And the EEOC cited to the administration's executive order that I discussed earlier, which directs federal agencies to only recognize 2 sexes, male and female. One of the dismissed cases actually was down in Santa Clara at a cosmetics store where the EEOC charged a manager for sexually harassing 3 gender nonconforming employees. It's interesting to see that the EEOC is moving to dismiss its own cases because just last year they had issued guidance which specifically clarified workplace harassment to include examples of misgendering and harassing trans workers. So for example, the guidance stated that use of incorrect pronouns for an employee or denying them access to restrooms that corresponded to their gender identity constituted harassment. And the reason why, the EEOC had issued that guidance is because just in 2023 alone, the EEOC received more than 3,000 charges of discrimination on sexual orientation or gender identity, which is the highest number yet since tracking began in 2013. So this shift to not protect transgender and gender fluid people who are clearly facing workplace harassment, um, it's pretty serious and has also been recently affirmed by a decision in a case in the Northern District of Texas, which was decided just this month, which found that EEOC guidance on gender orientation and sexual identity harassment was unlawful. Specifically, the Texas court struck down the guidance that misgendering employees or preventing access to restrooms corresponding to gender identity constituted harassment. The court also struck down language defining sexual orientation or gender identity as a protected class. So while this case decision doesn't change the law, it definitely impacts the rights of gender fluid or trans people to report workplace harassment. But as Ben kind of noted as one of our overall themes, this is something that might have come out differently if it was heard in California based on the state's general views towards gender identity. And so that's interesting and important for employers to consider. And the administration's targeting of gender identity rights has started to really shift the protections available to trans people and gender fluid people in the workplace. So as I'll discuss next, we're also seeing changes with DEI policies and racial discrimination from the Biden administration. So this is a 2024 decision from the National Labor Relations Board, also known as the NLRB, which involves an employee who had handwritten letters on his work apron that said BLM, which stands for Black Lives Matter. And several other employees at this same Home Depot store also had the markings on their work aprons around this time. Essentially, the store was having issues with a manager who was allegedly discriminating against employees. And so this was part of a larger protest against that manager and kind of the management's inaction to the racial discrimination that was ongoing. But essentially, Home Depot actually terminated this employee for refusing to remove the BLM letters written on his apron. But the National Labor Relations Act protects employees' right to engage in concerted activity for conditions that affect their workplace, such as racial discrimination. And so they found that the employee refusing to remove the BLM letters constituted concerted action related to the employee protests about workplace racial discrimination. And because those protests were an attempt to bring the complaints to the attention of management, this conduct was in aid of their cause and pretty notable in terms of the working conditions at Home Depot. So the NLRB noted that an employer's interference with an employee's right to display protected insignia, such as the BLM marking here, is presumptively unlawful, and it would be the employer's burden to establish circumstances making the rule necessary to maintain production or discipline. So basically, employers can't interfere with employees' right to display protected insignia. Here was the BLM marking, but you can also imagine it might be like a union insignia, because employers need to meet this pretty high burden of establishing special circumstances that make it necessary to maintain discipline. This also signals that workers have the right to join together to improve their working conditions, including by protesting racial discrimination. But this case was in 2024, and since then, the Trump administration has issued the executive order to, quote, end illegal discrimination and restore merit-based opportunity. So while that order doesn't change private sector employers' duties under the current law, we do wonder whether the outcome of this case would be different now if it would be interpreted to, you know, be promoting DEI preferences. So this case is an important example for employers to be aware that this kind of speech might be a protected activity and could lead to a discrimination claim. Social media, as Ben mentioned, also has played a large part in crafting the landscape of recent discrimination lawsuits. So this next case also involves speech around BLM, but here an employee's off-work comment on social media became an issue. So this case was in the Eastern District of California, and it involves a Sacramento radio host whose show was based on the local basketball team, the Kings. And plaintiff's show was a play-by-play commentary during the Kings games and had related basketball content. I wouldn't know, I don't really follow basketball. But in 2020, a week after George Floyd's killing, a former Kings player asked plaintiff here on Twitter, now X, if he supported BLM, to which plaintiff responded stating all lives matter. Plaintiff's tweet immediately elicited a lot of commentary, most of it critical, including from Kings players and listeners of the radio show, basically saying that he needed to be taken off the radio and couldn't represent the team anymore because his viewpoint differed from theirs. And so this case actually was just in a few months ago in March 2025, the court granted the defendant's motion for summary judgment, arguing that the plaintiff's claims fail because the labor code sections, which we discussed earlier, would violate the company's constitutional rights of free press and expressive association. So this is a bit of a niche exception here, but essentially because plaintiff was a radio host, so he was a public-facing employee whose job was to speak for the company, and this comment on X went against the show's intended style and tone and lost all credibility with the show's audience. So basically the court, in granting this motion, said that the process of creating an expressive work like a radio show would involve decision as to who gets to participate in that show. And so that's entitled to First Amendment protection because it can't be separated from the expressive content. So that's a really niche decision. This wouldn't apply, to other employees at the company, such as receptionists but here, because this was a casting decision for the host, it necessarily intertwined with the employer's ability and right to free speech. So while this is a unique application, employers should be careful about action upon employees' social media posts because it can often lead to litigation. And the California Labor Code sections typically block an employer from acting upon an employee's off-work political activities. But the Trump administration is also drastically altering permissible political expression at the workplace, especially in the executive branch, which is what I'll discuss on this next slide. So along the lines of the BLM apron that the Home Depot employee was wearing and kind of making political statements at work based on what you're wearing and with certain slogans or meaning, the Office of the Special Counsel recently came out with an advisory opinion related to the Hatch Act. So this act has an interesting history that I will spare you, but essentially it restricts federal employees in the executive branch from political activities. And this makes sense, right? It's to ensure that federal programs are administered in a nonpartisan manner and to protect federal employees from political coercion and to ensure that the employees in the executive branch are promoted based on merit instead of political affiliation. And so these restrictions on political speech mostly pertain to executive employees in the intelligence and enforcement type agencies. So you might think of the FBI, the National Security Council, or the Federal Election Committee. And And so political activities under this act are defined as campaigning for candidates or engaging in political activity. But employees are still allowed to like contribute money to campaigns or attend a rally. So essentially, this 2025 advisory opinion states that after election day, this act doesn't prohibit employees from wearing campaign items on duty because technically a candidate is no longer a presidential candidate specifically is no longer a candidate after the outcome of an election because they retain their status past the election if elected. So essentially, after the election, employees are allowed to show support or opposition to a presidential candidate because it won't impact the results of the election. So basically, it won't be considered political activity anymore. Um, so while the opinion goes on to state that, of course, employees can't engage in activity showing support for a political party while on duty, they're still allowed to show support for a political candidate. Um, so if this sounds confusing, it's because it kind of is. You know, wearing a t-shirt supporting one presidential candidate or another is obviously a show of support for a specific certain political party in most instances. And so this really is the administration, choosing and selecting specifically what kind of political speech is permissible in the workplace, while silencing other speech that it doesn't deem permissible, such as, diversity efforts and transgender rights. And these
Jackie,
kind of issues.
if I could
Oh
just jump
yeah,
in real quick,
yeah, of course.
Jackie's talking about, the public employees, people who work for the government, and as we all know, the Make America Great Again hat, it brings up a lot of strong feelings among people who, if they believe in that, they feel very strong about it, and it can make other people feel very uncomfortable. And during the first Trump administration, I represented an employer who dealt with an issue that hinges on the discomfort some people feel about the Make America Great Again hat, but also the intersection between that and social media. The employer had an employee who managed that company's social media account. It was a part-time job. And the employee's other role, they had another part-time job working for a local government in California. Around that same time, it's kind of a convoluted story. There was an incident at a Starbucks in Palo Alto where a Starbucks barista basically yelled at a man wearing a Make America Great Again hat and forced him to leave the Starbucks store. That woman got fired by Starbucks. And the plaintiff in the case I was working on then made a post on social media about it, basically saying, what it was not a good thing that this woman was fired. She was expressing her own speech, and he made a comment about like Michelle Obama says, when they go low, we go high, and the Make America Great Again hat, completely goes against that idea. And the company that he worked for as a social media manager, their clientele was mostly conservative people. And so they started to get a lot of really a lot of comments about their clientele feeling very uncomfortable about what this person had said online. So they ended up terminating his employment for that reason. And so he brought a claim, which was violation of the labor code sections that Jackie was mentioning before, saying that he was fired for his political speech. The company's response was, well, he actually violated our social media policy, and in a way that could really harm our bottom line. Ultimately, the case settled, but there was a really fascinating interplay between that, those labor code rights addressing political speech, and also, the employer's boundaries, and when they can feel comfortable enforcing their speech policies. So again, Jackie, I know you're going to continue talking about public employees, but I just wanted to interject with that.
Yeah, thank you. Yeah, so kind of tying that in, these issues have also come up for California government employees. So this next case was brought by the Progressive Democrats for Social Justice, which is a political organization, and two of its officers, as a challenge to the constitutionality of California's Government Code Section 3205. The two individual plaintiffs were public defenders for Santa Clara, who supported a fellow county deputy public defender's campaign to become the district attorney. And they wanted to solicit contributions from other public defenders, but this code prohibited them from doing so. And so this code held that local government employees could not solicit political contributions from coworkers, but state government employees could. Um, and so within some limitations, of course, state employees couldn't solicit during work hours or use state resources, their titles or positions when fundraising. But the court found that this code section was an unconstitutional ban on the First Amendment, because while it addressed the state's interest in freeing government employees from, coworker coercion to support political campaigns and ensuring a nonpartisan workplace, it wasn't properly tailored because it only applied to local government employees rather than state government employees. California tried to justify this distinction of the local versus the state government employees based on the ability of state agencies to protect employees from retaliation versus local government agencies, but the court didn't really buy that argument because they didn't provide any supporting evidence. So now in California, the 1 million plus local government employees can engage in fundraising just like state government employees. But it's notable that the California legislature could reinstate this rule, but it would have to apply to both local and state government employees. So now I'll turn it over to Ben to discuss how the administration's focus on anti-Semitism has shaped recent litigation.
Thank you, Jackie. There have been an uptick in lawsuits by both Jewish and Muslim employees since the October 7th attacks in Israel and Gaza, and in the aftermath in Gaza, addressing employment discrimination based on religion. We're going to go into two of those examples. Like Jackie mentioned before, the Trump administration's executive order addressing anti-Semitism, we're already seeing it having an impact on lawsuits that have been filed this year. The two examples we'll be talking about today actually happened before the new Trump administration came in, but they do prevent a useful backdrop. So, in this case, it was a case out of the Central District of California filed last year. And there was a Jewish sports agent who posted on Instagram after he saw this post that's on the screen here by Black Lives Matter Chicago. This post was made immediately after the October 7th attacks. Before Israel's response really occurred, that said, "I stand with Palestine." The Jewish sports agent wrote about his shock and disgust about the statement, and BLM Chicago's apparently pro-Hamas political stance. He was pretty quickly contacted by HR and told that they had received complaints about his comment, and he decided to take it down the same day. Interestingly, Black Lives Matter Chicago also took their post down, within a day, noting that it was insensitive. There was an investigation into the plaintiff's post, and ultimately his employment was terminated for violations of the company's social media policy. This is kind of it deals with so many of the issues that we're talking about today. The challenge of addressing employee speech following the October 7th attacks has been really central to a lot of companies because the Many people feel that those attacks, what happened was obviously unacceptable, and then many people also feel that Israel's response afterwards has been unacceptable. So there's been a flurry of employee speech on public forums expressing their views on this, and it's a hard balance to strike of, what is the employee's personal political speech, and what is speech that, even though it happens outside of the workplace or on public internet forums, when does it cross the line of violating the company's policies? This is a case that is still going on. The answer was filed just about a month ago. So we're going to keep a really close eye on it and see where it goes. And if there is a substantive ruling on the merits, it may help shape future litigation on these topics. Here's another very interesting case in federal court in New York, which was a former Israeli Defense Forces soldier who worked at Intel, who basically had been shifted to reporting to a manager that he believed was Egyptian and Muslim. And about a week after he had started reporting to this manager, that manager asked about his Jewish identity and his background in the IDF. Apparently, the manager saw that on his LinkedIn page. And he was terminated soon after that conversation happened, and he drew the conclusion that, he was terminated because of his Jewish identity and his background as a soldier in the IDF. Interestingly, meanwhile, that manager had been posting comments on social media and liking other comments by other people, including the one shown on the screen here, which appeared to celebrate the deaths of Israeli soldiers. That confluence of what happened to his employment, while meanwhile that employer, liking these very charged comments on social media, led to this lawsuit against Intel. And an interesting aspect of this is that Intel as a company has a long history of supporting the Israeli government, and after the October 7th attacks had donated a lot of money to Israel and hospitals in Israel. But that did not, make the company immune from lawsuits, religious discrimination lawsuits based on what happened here. Now, this case resulted in a settlement just a few months ago, but this type of pattern of the connection between what happens to the individual's employment and meanwhile what's happening on social media is something that we expect to see moving forward. We focused on two lawsuits here brought by Jewish plaintiffs, but I do want to note that there have been several lawsuits also filed by Muslim employees who felt that they faced discrimination for making pro-Palestine comments after given the kind of the heartbreaking Israeli response to what's happening in Gaza. And there have been a similar pattern there of a combination between an employee making speech about their personal views and the interplay between running against the employer's social media policies. Now, another issue that I'm sure many of you have noticed is kind of this challenge of how do companies decide which current events they're going to make comments about, from the employer perspective. I think there was a period of time where employers were making comments about a lot of current events, a lot of hot button issues in the news. Companies would err on the side of making some sort of comment about it. I think that's evened out a little bit, and employers are a little bit more circumspect now about what they're going to make comments about. And this is a difficult balance to strike because we know that employees they want to feel proud of their employer's stance. There was a New York Times survey that said that 61% of millennials want their employers to engage in social media. social issues, and about half of them said they would quit if their company had contrary values to their own. Um, so there's a couple considerations to keep in mind here. Employers should be aware of what precedent they're setting. If they're making a comment about one issue, does that sort of lead people to expect them to make comments about other issues? And what if they don't? What does that say about their values and what they care most about? Just to kind of use a key example, if an employer, said they were upset about what happened on October 7th, but they did not express a comment about the aftermath and what's happened in Gaza afterwards. Could that make their Muslim employees feel uncomfortable? And one kind of solution that we're seeing many employers take is to address issues that are directly relevant to the company. Now, I kind of can't help myself because I was proud of Farella's response to what was happening in the news recently. So here's an example of Farella's comment about, the administration's attack on certain lawsuits. That is an issue that is directly relevant to a law firm and what we do every day. It was one that, our law firm made a statement on. Now, I want to save a couple minutes for questions, but let me briefly address DEI policies. Um, you know, as Jackie was talking about, the Trump administration's view as DEI or illegal DEI is something that many employers are grappling with. And meanwhile, a lot of employees are very outspoken about this issue. And so, employers are trying to set that balance of, how do we address the federal government's response, while also making sure we're aware of state discrimination and harassment laws. Many states are saying like, okay, what the federal government is doing is what the federal government is doing, but California, for example, has said, we view DEI as an important way to eliminate discrimination or at least lessen discrimination and harassment in the workplace. So many employers are focusing on the side of, being conscious of what's happening on the federal level and being aware that their DEI policies could draw attention, but also, making sure that they're maintaining policies that employees feel strongly about and they feel are necessary to support the workforce. For some employers that are taking a look at it, I've noticed that some are keeping their quote unquote pipeline programs, which means, essentially making sure that they have policies in place to attract people of different backgrounds so that they are applying. And then, of course, when you're making the selection process, doing it equally based on business factors. That is one way that some employers have addressed it. But bottom line, if you're taking a look at your DEI policies, it's such a tricky issue that's a good time to reach out to counsel and bounce ideas off of them. So I know we're slightly over time. That is our presentation today.